Well, this afternoon we moved to another in the issues, one that's already been touched on, but we get to hear, I guess, another group of actors in these disputes. We get to hear from a couple of the litigators, one on each side, and specifically they're going to focus on the question that's already been raised of whether you whether a jurisdiction should adopt neutral principles or a governmental approach, a hierarchical deference approach. To introduce our panelists, I'm actually going to take my moderator cap off and be a panelist on this one, but to introduce me and the other people on the panel is going to be Mark Scarberry, another of our faculty members. Mark Scarberry, graduate of UCLA Law School, has been very involved in these issues. He serves on the legal advisory committee of the Presbyterian Church U.S.A., the same organization that Jim, our last panelist, is affiliated with. Of course, that denomination has been involved in much of this litigation. Mark, too, writes in the area of law and religion. He's got a very interesting piece coming out on John Leland, one of the early Baptists who was influential in shaping our law of religious liberty. Mark Scarberry.
Thanks, Bob. I'm going to introduce our panel, and then they will speak in the order in which I introduce them. So I'll introduce all of them, and then let them each come up. First, we will have Professor Robert F. Cochran, Jr., whom you've already met. He's the director and the founder of the Herb and Elinor Nootbaar Institute for Law, Religion, and Ethics here at Pepperdine. Undergraduate degree from Carson Newman, his law degree from Virginia. Co-author of several books, recently Law and Community, The Case of Torts. Another important book, Christian Perspectives on Legal Thought from Yale University Press, and other books on legal ethics and on counseling. Very, very interesting work. After graduating from law school, Professor Cochran clerked for Judge John A. Field, Jr. of the Court of Appeals for the Fourth Circuit, practiced with Boyle and Bain in Charlottesville, and since has visited at University of Richmond and Wake Forest, and we're very pleased that Bob will be speaking. Second, we will have a very distinguished litigator and writer, Jeremy B. Rosen. He's a partner at Horvitz and Levy. Represented the Episcopal Diocese of Los Angeles of the Protestant Episcopal Church in the United States of America in the case, and recently won the case in the California Supreme Court that has been mentioned. Undergraduate Cornell, law degree, and an LLM from Duke. Very active California Supreme Court practice, lead appellate counsel in dozens of appeals in a wide variety of areas. Prior to Horvitz and Levy, he was with Munger, Tolles, and Olson, and he had judicial clerkships after law school with Ferdinand Fernandez of the Ninth Circuit and Matt Byrne of the District Court for the Central District of California, and we have another participant later on who was a clerk for Judge Byrne. So we're very pleased that Jeremy's with us. Steffen and Johnson. Another very distinguished litigator, a partner at Winston and Strawn, represents the Falls Church and Truro Church, and I'm not sure, maybe a couple of the other of the churches in Virginia, the Episcopal churches that have sought to leave the Protestant Episcopal Church of the United States of America and affiliate with a new Episcopal group under a different bishop. Successful there as well at this point in the trial court, and waiting, I guess a notice of appeal was filed. So we will see what happens with that. Undergraduate, St. Olaf College, law school, Minnesota, part of Winston and Strawn's nationwide appellate and clinical motions practice. He's argued cases in the U.S. Supreme Court principal brief writer in a lot of cases, about more than 40 cases in the Supreme Court. Previously served in the Office of Legal Counsel in the U.S. Department of Justice. And in that position, he had responsibility for advising the White House and the administration on matters of church and state, including federal regulations for prayer in schools, the president's faith-based initiative. That was from 2002 to 2005. And he's taught religion and the Constitution at the University of Chicago. He also had a clerkship with Donald Lay of the Eighth Circuit. So we have three wonderful panelists. I can't wait to hear what they have to say, and we will start with Professor Cochran. Should I say a word about Jones versus Wolf and Watson? I think we'll let our panelists talk about that. Very good.
Well, I find myself sandwiched in between two of the litigants in this litigation that spoke before we had lunch, and then following me are going to be two of the lawyers that are involved in that. But lest we get too practical, we felt we needed to have a law professor step in here and at least take us back to the ivory tower for a little bit and think at a theoretical level about this. You can't run a conference like this without kind of getting involved in the issue yourself, and so I've gotten involved. Actually, Dean Starr and I wound up doing an amicus brief in the California case on what wound up being the losing side. But I wanted to step back from some of the more particular. The facts that particularly relate to the church disputes and try and view these disputes from a broader perspective. I titled my talk, "Breaking Up is Hard to Leave in the Private Sector." Some of you won't get that one. I guess those of you that are over maybe 40 or so, with apologies to Neil Sedaka. I mean, those of you under 40 won't know who that is either, but Breaking Up is Hard to Do was not that great a song, but anyway. You do what you can to lighten things up. But I say breaking up is hard to keep in the private sector, focusing on one of the points that I'm going to make as I go on. Just to put this in the context of some of the things that were said by the first panel, the notion of individual autonomy was suggested as maybe an alternative to religious ways of interpreting the Constitution, religious ways of answering free exercise and establishment questions. But I want to look at kind of a different perspective. Approach this from a communitarian perspective. As Robert Bella and his colleagues noticed in Habits of the Heart, our first language tends to be individualism, so we tend to jump into an individual autonomy analysis of things. But in fact, the habits of American hearts tend to be more communitarian, and I want to talk a little bit about the communitarian movement, how we might view things, and then try and draw some conclusions, which I'm sure some communitarians would disagree with me over, but that's the way with us. Communitarian theory looks at the individual and the state, and then tries to identify those communities that fall between them, sometimes called institutions of civil society, but it's the family, it's religious congregations, it's charitable associations, all sorts of voluntary associations. I guess as I reflected on this today, religious denominations would fall in there as intermediate associations as well. Communitarians see the importance of these intermediate institutions in protecting the individual. I mean, the focus isn't that these associations have value in their own right, but that these associations can protect and defend individuals from what might be, the harsh realities of life alone or life just with the state to look to. Just some positive aspects of intermediate communities. It's not just a matter of instrumental value, but number one, they have inherent value within communities. Individuals find fellowship and friendship. Two, psychological formation, as Michael Sandel has noted. Community is constitutive of the self. That is, community is the source of one's self-understanding. Number three, moral formation. I mean, communities are people's moral starting place. From the values that you draw from community, you might wind up then becoming self-critical of your own community's values. But for I think most of it's within us, it's within families and religious congregations and other intermediate communities that we develop our moral values. Tocqueville called communities little schools for citizenship. We learn to relate with one another in small communities, and then at least hopefully we're able to relate to others well in broader communities and the broadest community. Four, social services. Well, we hear the term social services and we think in terms of government-provided social services, but of course, intermediate communities provide an enormous number of social services. If you didn't have families and churches and schools to provide things, care for children, education, et cetera, if all of this had to be placed on the back of government, we'd have an intolerable situation. Social services provided, a whole lot by families, a whole lot by religious congregations as well. As John Paul II has said, needs are best understood and satisfied by people who are closest to them and who act as neighbors to those in need. Pointing to, maybe these groups are the best source of providing these, meeting these needs. Five, protection from the state and the alienating megastructures of modern life. I mean, it's not just the state, it's big business, it's big unions. Without smaller institutions to soften the harshness of those, to serve as a buffer, life would be tough. Six, prophetic insight. Religious communities in particular have been foremost or at the forefront, not alone, but at the forefront of the American Revolution, the anti-slavery movement, child labor reform, labor rights, maybe not all the greatest, prohibition as well, but anti-Vietnam War, civil rights movement. So all positives of intermediate communities and churches among them, positive in these ways. Well, the picture's not all pretty. Intermediate communities as well have their dangers. I mean, some have evil values. Communitarians are willing to say that. Sometimes these days to say that something is evil is sort of shocking, but communitarians are willing to acknowledge that neo-Nazis have it wrong, that there are communities that have evil values and need to be challenged. Two, excessive paternalism. Where the line is drawn is hard to identify, but most would certainly acknowledge that some communities, some families, some religious congregations go too far in directing the lives of their members. Three, neglect of broader communities. I mean, there's a danger with the intermediate communities that they'll become insular, that you'll have gated communities, that people won't be concerned with the outside world. Ideally, they're little schools for citizenship. Sometimes they're not. Four, conflict among communities. I guess there's a danger that communities won't merely ignore other people, but they'll kill other people. If we look at places like Ireland in the past, Bosnia, Rwanda, the Middle East, some of those today, some of those in the not too distant past, we see that. But on balance, communitarians say it's good to strengthen intermediate communities. This is rooted in our history. I already mentioned Bella. de Tocqueville, who actually coined the phrase habits of the heart, noticed that we Americans, unlike, folks in other countries, are very much creators and joiners of communities. Unfortunately, though, as Robert Putnam noted in his book, Bowling Alone, we're sort of getting away from that. People don't join bowling leagues as much as they did in the 50s and 60s. People tend to bowl alone. And that's his metaphor for, a lot that's going on with American societies as people move around, et cetera, et cetera. This thought is grounded in a host of different religious and secular traditions. You can find it in the Catholic doctrine of subsidiarity, in the Calvinist doctrine of sphere sovereignty, and you find it in secular figures as, diverse as Edmund Burke and Karl Marx. Families and religious communities are probably the most important intermediate communities, at least if you judge by individual identity. I think it's safe to say that. You've probably got the most people that would identify a strong part of their identity with their family or their religious community. Well, what does that help to say us to think? How does that help us to think about religious congregations and their conflicts? Well, what I want to do is to compare two of these communities, families and religious congregations, and compare the way that the law has treated families with the way that it is treated and might treat religious congregations in situations such as the breakup that we've been talking about. I find pretty strong parallels in the way that governments have treated both forms of communities. Number one, generally speaking, a great respect for privacy of the intermediate association, with some exceptions, but narrow exceptions, but generally a sense that we shouldn't interfere with the privacy of these intermediate communities. You see both a doctrine of family privacy and a doctrine of religious autonomy, which the state tries to respect. It likes to leave them alone. Well, two exceptions that I'll note. I think that the two major ones that I think of are number one, when somebody's bodily integrity is at risk. We've got neglect and abuse petitions where the state will step in. Generally, parents are allowed to raise their children as they want. And then on the religious side, in recent years, we've of course had the sex abuse scandals, and there was hesitant initially, I think, for the state to step in, but we've seen as the knowledge of this scandal has grown, the state stepping in both with criminal prosecution and tort law. The second time the state steps in is when there's a breakup, and of course that's the one that we're most concerned about. Now, Rick Garnett was supposed to be with us and was going to address these kinds of things. He's raised an argument for the hierarchical deference standard that's based on religious autonomy, and that really hasn't been mentioned much here today. His argument is if we allow states to get in and resolve these disputes, that's going to be the nose under the camel's nose under the tent, and then government's going to be regulating everything. Well, I guess as I look at the family disputes, it seems to me that and what's gone on there, it seems to me that the state can carve out an area where it is going to interfere, and that won't automatically lead to it jumping in and running everything. But anyway, generally speaking, deference with a few exceptions where the state needs to step in. The other historic pattern I've seen is that the rules here, the law here has moved from, in both areas, hierarchical deference to respect for individual autonomy. How have courts resolved different disputes? Well, we see the same pattern. As the United States has moved from a hierarchical society to a more egalitarian society. In family law cases during the 19th century, courts applied a hierarchical deference rule in both custody and property matters. As to custody, 1852, the California Supreme Court said the father got custody in a situation, even though the father was a bigamist and the child was illegitimate, but he had, quote, unquestioned right to the child's custody. In 1931, the legislature amended that to create a preference for the mother of a child of tender years, but if a child is, quote, of an age to require education and preparation for labor and business, then it goes to the father. That was 1931. It wasn't until 1970 that legislation was changed. It's hard to believe, to create a better interest standard. Property. I mean, California's community property, right? It's sort of equal. Well, between 1850 and 1973, courts deferred to the husband's managerial control of family property, despite the fact that we were a community property state. The movement from hierarchical deference, it seems to me, to neutral principles, respect for autonomy, allowing husband and wife to work things out between them as to how matters are to be dealt with. And of course now, even in common law jurisdictions, equal control of property within the family. This move towards a more egalitarian model. And we've already seen traced, it seems to me, the Supreme Court moving in the same direction, with originally Watson, the hierarchical deference rule, to Jones, a neutral principles rule. Well, what do you do when neutral principles, it seems to me that the direction that the courts have been moving in this other area, maybe a little slower in the church property area, but that it should move in light of the egalitarian direction of society, is to neutral principles. Well, what do you do when neutral principles don't provide an answer? What should you do? Well, it seems to me that the only alternatives are a rule which generally prefers the hierarchy, or a rule which generally prefers the congregation. And I think, as a communitarian, as I wrestle with this, the question which I haven't really seen addressed is, which would be better for the individual members of that community? And I'm not sure that I know the answer to that, but I tend to think, and I have to admit that my Baptist background may sort of lead me in this direction. I'll acknowledge my prejudice, but that for the individual members of the communities, it would be best if the congregation were the one that, if that were the direction that we meant in situations where there was not a clear answer provided by agreements that had been reached between the congregation and the denomination. And I'll just give you one ironic quote in support. Well, I already gave it to you. John Paul II said, John Paul II, of course, the head of the largest intermediate community in the world, praised the smallest of the intermediate communities when he says needs are best understood and satisfied by people who are closest to them and who act as neighbors to those in need. Thank you.
Would like to thank the Pepperdine Law School for their very kind invitation to participate in this outstanding conference. In particular, I'd like to commend Dean Starr for his outstanding leadership of this extremely vibrant intellectual community, and to Professor Cochran for organizing this conference. I would also be remiss if I did not also thank my favorite Pepperdine reference librarian, my wife Jody, who helped pull materials for me for this speech, and who, more importantly, puts up with me on a daily basis. Before I get to the substance of my remarks, I also need to make a very lawyerly disclaimer. I am here speaking on behalf of myself and not on behalf of any clients, and therefore all opinions expressed today are my own, for better or worse, and you can be the judge of that at the end. During the 1988 presidential campaign, then Vice President George Bush discussed what was going through his mind after his airplane was shot down and he was floating in the Pacific in a small life raft. He said that he, quote, thought about mother and dad and the strength I got from them and God and faith and the separation of church and state, unquote. It might seem a bit unusual that a young fighter pilot would think about the First Amendment separation of church and state while alone on a raft in enemy waters. But it would not seem odd to our founding generation who saw this issue in life and death terms. Indeed, the vital importance of the First Amendment helps explain why courts today routinely defer to a hierarchical church's decisions regarding the ownership of church property and other matters of internal church governance. I've been asked today to speak about why courts should defer to the decisions made by hierarchical churches over the ownership of church property when disputes arise between competing factions of a church, rather than look instead to the so-called neutral principles of law to determine who owns the property. To do so, I will first examine some historical background to the enactment of the First Amendment. Then I will explain why such hierarchical deference is vitally important to religious freedom in this country. And finally, I will make a few observations about the real meaning of the neutral principles concept as set forth by the United States Supreme Court, which actually provides significant deference to the rules set by hierarchical churches. To understand the important historical reasons why the founders of the United States would have been concerned about the power of the government to adjudicate property disputes between competing members within a church, one need only look to the events of unfortunate government entanglement in religion in England during the preceding 600 years. Now, I won't try to discuss everything that happened in 600 years, but a few examples. In the 12th century, Henry II was so angered by Thomas Becket, he had him convicted on trumped-up charges, had his property forfeited to the crown, and ultimately caused his murder. Any other clergy who followed Becket's interdict against the king also had their property forfeited. In the 13th and 14th centuries, Edward I and Edward III took the property of the so-called alien priories, which had been founded shortly after the Norman conquest. Their crime was continuing to keep a close relationship with their mother monasteries in France. Between 1536 and 1541, Henry VIII disbanded monastic communities throughout England and seized their lands for the crown. 578 monasteries and 130 convents were closed, displacing over 6,000 monks and 1,500 nuns. Numerous other examples of religious discrimination were prevalent, many directly causing the early waves of immigration to the new colonies in America. Indeed, a backlash to these practices of government entanglement in religion and property included the making of decisions about church property began to take shape in the 13 colonies and were reflected in many of their early governing charters. For example, the 1649 Maryland Act concerning religion provided that no person shall from henceforth be anyways troubled, molested, or discountenanced for or in respect of his or her religion, nor in the free exercise thereof within this province. The Pennsylvania Charter of Privileges in 1701 provided that no person shall be in any case molested or prejudiced because of his or their conscientious persuasion or practice, nor be compelled to frequent or maintain any religious worship. Now, these colonial charters were admittedly somewhat limited in that they tended to provide religious freedom only for the wide range of people who believed in Jesus, and excluding other faiths. However, these charters did represent a monumental improvement over the European example. Now, the First Amendment to the U.S. Constitution went much further than those colonial charters, broadly providing that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Or, as the Baron de Montesquieu wrote in his seminal work, The Spirit of the Law, we ought not to decide by divine law what should be decided by human laws, nor determine by human what should be decided by divine laws. It is with this backdrop that the United States Supreme Court decided Watson versus Jones in 1871 and addressed the proper role of civil courts in resolving intra-church property disputes. There, the court was faced with determining which faction of a local church properly owned the church's property. The highest judicatory within the church decided that question in favor of one of the factions, and the issue before the Supreme Court was the effect to give that decision. The Supreme Court began its opinion by expressly rejecting the prevailing doctrine in English courts that it is the duty of a court to determine which competing faction in a church is the proper owner of the property. As the Supreme Court explained, we can very well understand how the Lord Chancellor of England, who is in his office, in a large sense, the head and representative of the established church, should feel, even in dealing with a dissenting church, but little delicacy in grappling with the most abstruse problems of theological controversy or in construing the instruments which those churches have adopted as their rules of government. By contrast, in the United States, the Supreme Court noted that the right to organize voluntary religious associations, to assist in the expression and dissemination of any religious doctrine, and to create tribunals for the decision of controverted questions of faith within the association, and for the ecclesiastical government of all the individual members, congregations, and officers within the general association is unquestioned. All who unite themselves to such a body do so with an implied consent to this government and are bound to submit to it. But it would be a vain consent and would lead to the total subversion of such religious bodies if anyone aggrieved by one of their decisions could appeal to the secular courts and have them reversed. More than 80 years later, in Kedroff versus St. Nicholas, the Supreme Court had to decide which of two competing factions controlled a particular cathedral. The court again reiterated that even in those cases when the property right follows as an incident from decisions of the church custom or law on ecclesiastical issues, the church rule controls. This, under our Constitution, necessarily follows in order that there may be free exercise of religion. In an important concurring opinion, Justice Frankfurter explained why control over property is so central to the free exercise of religion. St. Nicholas Cathedral is not just a piece of real estate. A cathedral is the seat and center of ecclesiastical authority. What is at stake here is the power to exercise religious authority. Put another way, were a civil court to resolve an internal church dispute over who owns property by refusing to accept the church's own rules, the civil court would be entangling itself in a religious dispute and would be passing judgment over church doctrine. In sum, as the California Supreme Court weeks ago explained, respect for the First Amendment free exercise rights of persons to enter into a religious association of their choice requires civil courts to give effect to the provisions and agreements of that religious association. The final question to address today is whether the use by courts of so-called neutral principles of law to decide intra-church property disputes has weakened the commitment to hierarchical deference. The short answer is very little or none at all. And let me explain. The United States Supreme Court's 1979 opinion in Jones versus Wolf, which addressed competing claims of ownership in a local church as a result of a schism, broadly reaffirms the importance of deference to hierarchical church decisions, even though couched in the language of applying neutral principles of law. To begin with, the four-justice dissent disapproved of any notion of courts using neutral principles to resolve church property disputes because such a practice would violate the free exercise clause. In response to that dissent, the five-justice majority reasoned that the neutral principles approach, as they conceived it, would not frustrate the free exercise of religion because, quote, at any time before the dispute arises, the constitution of the general church can be made to recite and express trust in favor of the denominational church. The burden involved in taking such steps will be minimal, and the civil courts will be bound to give effect to the result, provided it is embodied in some legally cognizable form, unquote. Thus, the takeaway from Jones is that if there is a provision in the governing document of a church, civil courts must defer to it or else run afoul of the free exercise clause. No other evidence is considered. Thus, as defined by the United States Supreme Court and as limited by the free exercise clause, a neutral principles approach is still one that appropriately recognizes and enforces a hierarchical church's rule. I close with an insightful observation made by the great 19th century visitor to our young nation, Alexis de Tocqueville, who sought, among other things, to explain why religious faith was stronger in America than in Europe. He concluded that it was precisely because the government stayed out of religion and the religion stayed out of the government. As he put it, quote, religion can at times rely on the artificial strength of laws and the support of the material powers that direct society. There have been religions intimately linked to earthly governments, dominating men's souls, both by terror and faith. But when a religion makes such an alliance, I am not afraid to say that it makes the same mistake as any man might, It sacrifices the future for the present, and by gaining a power to which it has no claim, it risks its legitimate authority. When a religion seeks to found its sway only on the longing for immortality, equally tormenting every human heart, it can aspire to universality. But when it comes to uniting itself with a government, it must adopt maxims which apply only to certain nations. Therefore, by allying itself with any political power, religion increases its strength over some, but forfeits the hope of reigning over all." Unquote. Nearly 200 years later, de Tocqueville's words continue to resonate. With old churches in Europe no more than tourist attractions, yet a vibrant community of faith in the United States, the continued importance in separating church and state remains of utmost importance. Thus, when civil courts are called on to resolve intra-church disputes, they should continue to defer to the church's own decisions and rules rather than entangling themselves and governing churches themselves. This will ensure the continued preservation of religious freedom in the United States and is the appropriate role for courts today. Thank you very much.
Like Jeremy, let me begin by saying thank you to Bob Cochran and Dean Starr and Audrey Owens for inviting me to be here today. Just witnessing this morning's sunrise was worth the trip. And it's also terrific both to see some old friends and to make some new ones. And I'm honored to be included in such a distinguished group of scholars and practitioners. Before I turn to the topic, I can't resist commenting on the title of this conference, Who Owns the Lord's House? Now, maybe it's just me, but I can't help but thinking that only lawyers would suggest that not only is the answer to that question not obvious, but it may not be the Lord himself. That doesn't necessarily reflect well on our profession, but I take some comfort in the fact that I'm not being asked to debate that question with a minister or a theologian.
Let me just
lawyers.
interrupt. It was my choice, and it is intended to be an ironic title.
Now the disclaimer. Any case, since I'm debating this with lawyers, perhaps it's a fair fight. I should also give the same disclaimer that Jeremy gave, which is that I'm here in my own capacity as an individual and sharing some of my own evolving views about these matters, not necessarily the views of my clients. As the political ads go, I'm Steffen Johnson, and I approve this message. In my time today, I'd like to suggest 4 reasons why a neutral principles approach to church property disputes is sensible as a matter of public policy. I don't intend to argue that the neutral principles approach is the only valid approach, or even that it's necessarily the best approach. But the fact that some strong public policy considerations support it confirms that the Supreme Court was right to approve it in Jones versus Wolf. First, I think if we're honest, we have to admit that it's an extraordinary thing to say that adopting a denominational rule irrevocably transfers ownership of every affiliated member congregation's property to the denomination. If the Episcopal Church is right, for example, then they obtain ownership of the property of more than 7,500 congregations in all 50 states in one fell swoop, simply by passing a canon at a church convention. And this holds true regardless of whether the particular congregation at issue objected to the rule or even had notice and time to reflect on it. The Episcopal Church's Dennis Canon, after all, was thrown together virtually overnight. It was proposed late in the church's 1979 General Convention in the wake of Jones versus Wolf, and the church, in fact, had to suspend its rules for the introduction of legislation, which provided that legislation could only be introduced in the first few days of the convention. That was the only way that this canon could be voted on. Now, in contrast to provisions for amending the Episcopal Church's Constitution, which require votes at 2 general conventions with a 3-year waiting period in between, canons of the Episcopal Church can be adopted on a single reading. So under the denomination's view, several thousands of congregations nationwide in every state who had no actual notice that their property was on the line lost that property overnight. Now, I'm not suggesting today that a state may not choose to permit denominations to obtain ownership of congregational property by passing national denominational rules duly adopted with reasonable notice. But in addition to Jones' rejection of the view that states must defer to the hierarchical church in matters of church property, I think we're wise to remember that this isn't how property transfers ordinarily work. They usually involve execution of a deed, payment of consideration, title searches, and a host of other formalities, including signed documentation indicating that both sides agree to the terms of the transfer. Nor do denominational trusts created in this manner square with how trust law typically works. Ordinarily, a trust can be established only by a settlor, the party who holds legal title to the property. In the case of church property, that is typically, though not always, the local congregation or its trustees, not the denomination. And of course, trust law generally provides that it's the settlor who gets to decide who the beneficiaries of any trust are. Beneficiaries cannot generally assert a beneficial ownership interest in other folks' property. Now, some, including Jeremy, have argued and pointed out the perspective that the denomination, joining the denomination, and by agreeing to do that and to abide by the denomination's doctrine, the congregation grants the denomination the right to act both as settlor and beneficiary. At least that's the practical implication of these arguments. Citing Watson versus Jones, a federal common law case that we heard about both from Professor Greenawalt and from Jeremy, they say that acceding to the governance of the denomination requires acceding to the denomination's rules across the board. But in terms of equities, I think it's helpful to remember that this is an argument that's based on implied consent, especially when rules affecting property are adopted after the congregation joins the denomination. In terms of just plain old reasonable expectations, local congregations might well have viewed themselves as subject to church rules when it comes to doctrine, but subject to state law when it comes to property. After all, the law generally frowns on the notion that ownership can be transferred without some pretty explicit agreements. Clear title is usually thought too important to be left to implication. That's why deeds are so important, and that's why we have statutes like the Statute of Frauds. Moreover, as Lynn Moyer colorfully noted with her yacht club analogy, if you joined, for example, to continue a similar analogy, an auto owners association based on your shared love for cars or red cars, you would expect to be a subject to reasonable rules, including rules concerning how you use the club's name and its logo. But you would not likely expect the civil courts to enforce a rule adopted by your fellow members, perhaps over your objection, claiming that if you disaffiliate from the club gets your car. Indeed, even when voluntary associations are formed around property ownership, associations such as homeowners associations, the courts recognize implied limits on such associations' ability to pass rules affecting ownership of member property. Again, none of this is to say that religious denominations are never entitled to hold local church property, that they don't have free exercise rights, that states may deprive denomination of some reasonable means of holding local property, or even that states may not enact laws that give legal force to denominational rules affecting property. But if that's going to be the law, there are some good reasons why the state should be very clear about it. And the notion that the Constitution requires states to recognize the denomination's chosen means of obtaining such property interest, particularly when those means are so far removed from how property and trust law ordinarily work, is a hard sell. As the Supreme Court held in Jones, quote, "A state may adopt any one of various approaches for settling church property disputes, so long as it involves no consideration of doctrinal matters, whether the ritual and liturgy or worship of the tenant or the tenets of faith, and so long as it is, quote, flexible enough to accommodate all forms of religious organization and polity." In other words, whether the church is hierarchical, congregational, or some mix of the two. Put in terms of relatively modern Supreme Court free exercise jurisprudence, the court said it doesn't impose a cognizable burden on religious exercise, or the burden is too minimal to be constitutionally significant, to require denominations to take certain steps required by secular law to protect their property interests. And so, for example, it's perfectly valid for Virginia to adopt a presumption that when a group of congregations votes to leave a denomination, ownership will follow the majority of the congregation if, and only if, the property at issue is held by congregational trustees. Hierarchical churches in Virginia may secure ownership of their property by directing congregations to place title in the name of the bishop or another ecclesiastical officer, as do the Catholic and Mormon churches, or by directing congregations to place title in corporate form, as do many Methodist, Presbyterian, Lutheran, and Greek Orthodox churches. But the state has considerable discretion in deciding what the parties have to do to secure their ownership interests, to put them, in the words of Jones, in a legally cognizable form. That is the lesson of the Jones case, and I suspect that today's Supreme Court would be even more supportive of that view. A second consideration supporting the neutral principles doctrine arises out of the Supreme Court's decision in Presbyterian Church versus Whole Church. As others have noted, the court there held that civil courts may not invalidate a denomination's trust interest in local property on the ground that the denomination has left the faith or departed from its doctrine in some substantial way. Now, I suspect that most, if not all of us, would agree that Whole Church is right to say that civil courts are not well equipped to make theological determinations. But it's important to remember the implications of this holding for churches who joined their denominations before that decision. Many of these churches joined thinking that they had an escape hatch, that if the denominational leadership took a sharp turn in an unexpected direction, that the property that their members often paid for and maintained with their own money would stay with the local church, even if the church cut the ties with the mothership. In fact, many of these churches joined their denominations before the First Amendment, under the incorporation decisions of the 1940s, even applied to the states. I'm not suggesting that Whole Church is wrong, but it does seem to me that it's reasonable for states to consider the downstream effects of that decision, and that as a matter of the basic equities, it's wholly appropriate for states to say, well, if civil courts can't get into whether the denomination has lost its way in the eyes of the adherents, then we're going to provide other means for local congregations to order their affairs to retain their property. To be sure, Jones says there has to be some way for denominations to be the same. The law has to be flexible enough to permit different forms of ownership, different results, whether denominational ownership or congregational ownership. But it's reasonable for states to say, in response to Whole Church, denominational ownership has to be clear, and it has to be secured by following the rules that others have to follow to protect their property interests, such as recording those interests in the deeds or the land records. Which leads me to my third point. Church property cases involve some unusually complex equities. As Professor Brownstein noted this morning, religion is distinct from comparable secular activities, and I would argue that it threatens religious liberty to ignore that distinctiveness. This is true in church property cases no less than in other areas of law. For example, denominations are fond of saying that church property disputes are about ensuring that generations of loyal or faithful adherents to the denomination are not deprived of their property. And there's a case to be made for that perspective, as Jim Miller eloquently stated this morning. But I would argue that it's not fair to presume that church members' primary loyalty is to their denomination. It may be that their primary loyalty is to their local body, as we heard from Lynn Moyer, regardless of denominational politics and doctrine, or that their primary loyalty is to certain doctrinal views. And as Professor Greenawalt noted, many people choose churches based on clergy or geographical preference. My point here is not to say which of these loyalties is necessarily stronger, although some surveys say that regular churchgoers care more about their local churches and more about doctrine than they do about denominational affiliation. The point, though, is that church property disputes involve some particularly complex equities, with reasonable arguments on both sides. Different members may have had different intentions when they gave to their local church, and a state may reasonably create presumptive rules that favor either side. For example, the state might adopt laws requiring local congregation to notify members that gifts not containing express conditions to the contrary will be deemed to benefit the denomination. By contrast, a state might say, we presume that when title is held by the local congregation, support for the local congregation is meant to stay local. If a different presumption is warranted, then the donor should be express about it, or title should be transferred. That may not be the only valid approach. It may not even be the best approach in all circumstances. But given the complex balance of equities involved, it is certainly a constitutional approach. Fourth and finally, the state has a far greater interest in setting the rules for church property ownership than it does in governing or intervening in other matters, such as matters of doctrine or internal discipline. For example, I would say the state has no legitimate dog in the fight over whether a religious leader meets a denomination's moral standards. That's the lesson of cases such as Milivojevic, which held that the Illinois courts could not override an Orthodox denomination's decision to defrock a bishop on the ground that he no longer possessed the, quote, fitness to serve as bishop, end quote. The lower courts had held that the bishop's removal was arbitrary, but the Supreme Court reversed, explaining that questions involving the conformity of members of the church to the standard of morals required of them are strictly and purely ecclesiastical. The court's ruling thus rested on explicitly jurisdictional grounds, which you heard about from Professor Stephen Smith this morning. Property is different. The state has a strong interest in clear rules governing property ownership. Those rights can affect those rules can affect the rights of third parties, such as those who slip and fall on the property, and who is on the hook for compliance with zoning requirements. State property rules also protect those who wish to purchase or obtain a secured interest in property by enabling them to have confidence about who the real owner is, as well as title searchers charged with investigating that issue. In addition, in my experience, denominations can rely on the ambiguity over ownership to have some sort of an interorum effect that discourages disaffiliation and settlement and encourages litigation. Thus, assuming states may pass laws recognizing denominational interests not found in the deeds or a written trust agreement signed by the congregation, we still have to acknowledge that such laws are something of a departure from the clarity that normally attends property ownership. And I find it hard to see the view that the Constitution compels states to adopt such laws. In summary, I've attempted to offer 4 reasons why the neutral principles approach may be equitable, and why it should not be reduced to an approach of deferring to the hierarchy only by another name. Along the way, I've suggested that the most sensible reading of Jones is that it grants states broad latitude to set rules for church property disputes. Some such rules will favor denominations, others will favor congregations. And both denominations and congregations have a right to some reasonable means of securing ownership interests in local property. But the notion that Jones constitutionally requires every state in the Union to take a particular approach to church property disputes and to recognize denominational trusts not reflected in the deeds or the land records is not supportable under Jones, or for that matter, in our laboratory of democracy, sound principles of public policy. Thank you.
Now, we've set this up a bit like an oral argument, and so Jeremy has a few minutes here to respond.
Thank you very much. I'll just make a few points, as one generally only gets a few points in a rebuttal. I'd like to go back to respond to what Steffen just concluded with, which is his reading of Jones allowing the states to have all sorts of discretion in property. The problem with that statement is that that's not what Jones says. If you look at the language that I discussed earlier in Jones, when the majority was responding to the dissent, who would have said there could be no neutral principles, the majority said, quote, "At any time before the dispute arises, the Constitution of the General Church can be made to recite and express trust in favor of the denominational church. The burden involved in taking such steps will be minimal, and the civil courts will be bound to give effect to the result." Unquote. Now, this, to me, ends any discussion as to what courts are supposed to do when there is a clear canon or constitution of a hierarchical church. If there is a trust provision in that constitution, end of story. Now, the argument was made that courts should be able to look into whether or not the Constitution was properly amended or whether the rules of the church were followed, and so on and so forth. without getting into the merits of that particular argument in that particular case, that whole line of analysis is precisely the First Amendment violation, because civil courts should not be and are not permitted to, under the Free Exercise Clause, to go in and second guess the decision of a church over matters of doctrine or on the matters of church governance. Now, the point was made that property is somehow different. But as the Kedroff case made clear, especially in the concurrence by Justice Frankfurter, property is the essence, and many times, of the religious faith, because it's consecrated ground, it's the symbol of the religion, and decisions over churches goes to the essence of faith in many circumstances, and it is not an appropriate role for courts to get involved. And I guess, why don't we take questions? Those are the few points to make.
Very good, thank you.
Yeah, I had what Jeremy
Mike.
just said. Oh, sorry.
Take the mic.
A question I've long had, because I'll just say, years ago it seemed to me that the deference or hierarchy approach did seem the most attractive. And the doubt I've had is sort of suggests what you just said. I mean, even to apply it, it seems as if, in the first place, the court would have to decide, is this a hierarchical church? And what is the highest body? Right? They'd have to decide that in order to even apply the hierarchy approach. But then it seems, and Kent kind of suggested this in his talk, that it'd be a little bit cut and dry to imagine everything is either a hierarchical church or not. And if it is, we can just as a matter of fact, without getting into theology or anything, identify who the highest body is, because there seem to be lots of intermediate possibilities even within a hierarchical church, such as people think, well, that's the hierarchy, that's the body for some purposes, or if it acts in a certain way. So it seems to me that even to apply it, one would have to get into those kinds of issues which are theological in nature, and then you're left saying, well, we don't want to do that because the court can't deal with theological issues, but even to apply it seems to require a court to deal with those kinds of, I would say, theological issues. So what am I missing with that?
Well, I think you're absolutely correct to point out that any time we have a civil court resolving, whether it's by deference or neutral principles, a intra-church dispute, there is going to be some modicum of entanglement. So one model perhaps could be that you would say civil courts should never be able to get involved in any intra-church dispute at all. The problem with that approach, of course, is then you would have equal protection and free exercise arguments going the other way, that a church being rightfully dispossessed of its property should have the same right as anyone else to be able to use the civil authorities to retrieve it. Now, to get back to the substance of your question of doesn't there have to be some decision that may be doctrinal? I think that is true but unavoidable. But what I would argue, and I think the courts have said, is that you have to limit the nature of the intrusion and limit the amount of entanglement. And I think courts have been able to consistently identify which religions are hierarchical and which are not. If there was a true dispute over that, then I think that would be an interesting case. But in the situation where there is a clear and fairly undisputed hierarchy, then it would be to take a very minimal level of intrusiveness. And as Jones says, that when applying neutral principles as conceived by the Supreme Court, the hierarchical body can amend its constitution, but it has to do so in a way, and the exact language is to embody it in a legally cognizable form. And so I think that would address your concern, that there would have to be some plain piece of paper that says this is the constitution of the church, this is what it says, and then once it's or here's the decision of the highest adjudicatory body, and if it's in a cognizable form, then the entanglement must stop and the courts need to defer to that. And I think that's the way to resolve that. And if it's a non-hierarchical church, then neutral principles, sort of in the more grandiose and full form that have been discussed by both Steffen and some of the earlier panelists, would come into play, because their courts have nothing really to go on, and they have to do that. But to preserve the free exercise rights of hierarchical churches, if there's a clear decision or a clear canon, that has to be deferred to.
Two thoughts in response to that. First, how can it be less of an intrusion for a civil court to ask whether a church is hierarchical than to ask whether a canon is duly adopted on the basis of principles like, did a majority of the governing house adopt it? That I just find, to me, it's self-evident that the intrusion is greater when you're trying to get into debating expert testimony on how the church is organized. Civil courts are not equipped to make those determinations. They are equipped, and contra Bush v. Gore maybe, but they are equipped to count heads and say, okay, we can say that you introduced this piece of legislation on an appropriate day and that a majority of your House of Deputies or bishops voted for it. That is not nearly as great an intrusion. As to the point about what Jones holds and whether it requires recognition of the denominational canons, I don't have the case with me. But in context, the quotes that Jeremy has indicated refer not only to the minimal steps of amending the denominational constitution, they refer to the minimal steps of having to do something to the deed. And the court goes on to say that states have discretion to choose which of these means are used to, in that case, to overcome the presumption that majority rule govern property ownership. There was a remand in Jones, and there were no restrictions on the remand. They simply said to the Georgia courts, you decide how this majoritarian presumption is overcome. The only two limitations are no interference with free exercise, which the court explained means you can't arrange things such that denominations can't own property. There has to be a reasonable means for that result to be achieved, and no analysis of doctrine. And it seems to me that that's the natural reading of the natural implications of that case are that there are lots of ways states can approach this. They might choose to defer to the hierarchy, but not necessarily.
Could I use moderator's privilege here and ask a question? How does the question of identifying who the local church is play into this? Because even if the local church wins, even if the canon is held not to be effective, for example, yet if the hierarchy's determination of which group within the local church is the local church, if that's given effect, you get the same result.
Well, that was actually a central issue in Jones. Property ownership turned in significant part on identification of who the congregation was. And if you look at the briefs from the case, you'll see that the petitioners, the Presbyterian Church and the wing of the congregation affiliated with the Presbyterian Church in the United States, argued that it was the really problematical thing was for the Georgia courts to say who the wing of the congregation was.
Which one's the true church, the true local church. Yeah.
And the court's opinion, I think, reflects the fact that, well, it's one thing to say who the true wing of the church is from a doctrinal perspective. It's another thing to say we're going to set up some presumptions that this is who the civil courts are going to recognize as the owner. You have to be able to get around those presumptions, but that's what states can do. And it seems to me that that's in many ways that was the more difficult issue, identifying the wing of the congregation than determining who the owner of the property was. In that case, they were part and parcel.
But before I get into that question, I just found the proper language in Jones and wanted to go back to the earlier question to respond briefly to Steffen's point that the point in Jones that I was quoting talks about the deeds. Well, that's true, but also not quite the whole story. That what the Supreme Court says is there are two approaches that the hierarchical church can do. They, quote, they can modify the deeds or the corporate charter to include a right of reversion or trust in favor of the general church. Alternatively, the constitution of the general church can be made to recite an express trust in favor of the denominational church. So what Jones is saying is there are two possibilities of how you can ensure property is owned in trust for the hierarchical church. You can either modify the deeds, or alternatively, you can modify the Constitution. So I just wanted to clarify that. Now, getting to the question of the understanding the denominational church, I think that also brings up sort of an interesting question on the equities. There's been a lot of discussion, both by Steffen and some of the earlier panelists, about how unfair it is to the local congregation who has invested all this time and money. The problem is that you only know, to the extent that you can know, what the current members of the local congregation think. And unless it's a situation where the only money that has ever been spent on the church comes from the current members of the congregation, and that all 100% of them support breaking away from the national church, then you can't say that the equities go in favor of the congregation, because you have many congregations that go back 50, 60, 100, or 400 years, and you have no way of knowing the earlier people who contributed the contributions to that local church. Did they do so? The only thing that you do know is that they were giving the money knowing that the local church was part of a particular national church. And so the only logical assumption that you can make is that they were doing so because of that. Now, so I think that takes away some of the equities. Now, in terms of understanding who the local church is, I guess from my perspective, it's less important to know who controls the local church, because that's determined by the hierarchy, if it's a hierarchical church situation.
Just a couple comments on what's been said before. First, the question Steve raised about determining whether something is a hierarchical church. I mean, I've been following the cases in California, and right now you have two decisions, one of which is held that a Baptist church is hierarchical in nature, and one of which is held that a Church of God is hierarchical in nature. Well, those are two denominations that are so clearly congregational in form. I mean, they're used as examples when people are, describing what a congregational church is and what a hierarchical church is. You've got courts looking, oh, well, there's some denominational structure. This must be a hierarchical church. So, I mean, I don't think it's an easy determination to make at all. Secondly, as to the language in Jones versus Wolfe, I've got it in front of me as well. The sentence that Jeremy read falls in a paragraph and is sandwiched between language of plurality. I'll just read it. Under the neutral principles approach, the outcome of a church property dispute is not foreordained. At any time before the dispute erupts, the parties can ensure, if they so desire, that the faction loyal to the hierarchical church will retain the church property. They can modify the deeds or the corporate charter to include a right of reversion or trust in favor of the general church. And then we have the sentence that he read, just to read the last sentence to show the sandwich effect. And the civil courts will be bound to give effect to the result indicated by the parties, provided it is embodied in some legally cognizable form. Now, you English teachers among us, if there are any, listen to this sentence, the one Jeremy read. Alternatively, the constitution of the general church can be made to recite an express trust in favor of the denominational church. Now, those of you that are English teachers would probably mark that in red and say passive voice. Notice that there's no subject to that sentence. The Constitution of the General Church can be made to recite and express trust in favor of the denominational church. I mean, it's sort of Washington, D.C. speak. Mistakes were made. In context, it seems to me it's clear that that's what's required is agreement between the parties, not the denomination unilaterally amending its constitution.
Shelley.
If I can add one thought to that. I would suggest that the reading of Jones has to be informed by Georgia law as it existed at the time. And in fact, the court says at one point, under the neutral principles doctrine, at least as it has evolved in Georgia, and I read that as sort of an ongoing part of the discussion. I don't read Jones to say there's only one neutral principles doctrine and it always requires consideration of exactly the same elements, or the elements have to be considered in a particular order. I read it to say there are neutral principles that can be applied in church property disputes. These principles have to be principles that are capable of application to both secular and religious entities. But they need not be necessarily even uniquely applied or applied across the board. For example, I think the California Supreme Court was right to note, I think in a footnote in its opinion earlier this month, that we're not saying that states can't adopt laws that are specific to church property. And I assume Jeremy and I would agree about that point.
Okay. Professor Shelley
Yes.
Saxer, who's going to be, you're going to be
Yes,
hearing from a
thank
little
you.
later.
Okay, good. The question that I have goes back to this question of hierarchical or congregational. And I'm wondering if that has to be such a troublesome question, because I'm just trying to look at the basic structure of our analysis. If we say this is hierarchical, then we have a choice, I think, to apply, going back to Professor Greenawalt's language. We have hierarchical choice of either principles of government, which means you defer to the national body, or can we not use neutral principles for a hierarchical church? Going in and see how the canons were developed, what the relationship was with the local congregation. Alternatively, if we say it's congregational, then don't we have the principles of government approach that says majority vote? Courts can stop at that and say majority vote is all it takes for the local congregation. Principles of government. Or they can go to neutral principles and look at the documents, look at how the vote was taken. So I'm wondering if by saying congregational, does that mean we have to apply neutral principles?
No, I think the point is, if it's truly a congregational form, then however the congregation governs itself, it decides. And I suppose if there's an express trust in favor of a denomination, even though it's a congregational form of church, you'd enforce the express trust. But you wouldn't find an implied trust in favor of the denomination if it's a congregational church.
So I guess my question still is, though, do we have a choice, if it's hierarchical, of applying either neutral principles or principles of government? And if we find that it's congregational, we have a choice of applying principles of government or neutral principles.
Well, I guess I would just say that, well, first, let me back up a second. The U.S. Supreme Court in the Kedroff case defined what it meant by a hierarchical church, and it said that it's a hierarchical churches may be defined as those organized as a body with other churches having similar faith and doctrine with a common ruling convocation or ecclesiastical head. And I think if you take what Jones versus Wolf has said, that for however you want to, whether you want to call it neutral principles or deference, that when you have a hierarchical church who has a clear rule or a clear decision, then that has to be deferred to. If you have a congregational church, you can still have, I think, deference if there is a clear rule that has come out of the recognized matter of decision making in that particular congregational church. But I think that would probably most likely be weaved through a neutral principles analysis, which would give some great weight to the appropriate decision maker within the congregation and whatever that decision was, in addition to looking at some of the other factors.
Yes. Microphone.
Batteries, can I just talk out loud?
Go ahead. Well, being taped, here comes the mic.
Be nicer, I won't give it to you.
I agree with what Professor Cochran said about the context of that portion of the Jones v. Wolf decision that Mr. Rosen had quoted. I think it's in the context of a discussion about the intention of the parties. That phrase is repeated several times. And with respect to the suggested course of conduct to reflect that intent, amending the denominational constitutions, it seems to me that one of the parties must necessarily be the title holder of record. And if it's a corporation, it has no voice or vote or role in the denominational amendment process. If it's an unincorporated local religious association and congregation, the Presbyterian polity requires that before the congregation property can be alienated, a congregational vote is required, and that the individuals who attend a meeting of the presbytery where the Constitution's amendments are ratified are not there in a representative capacity. And so I don't think that you can take the language in Jones as authorization for a 50-state regime of unilateral ecclesiastical expropriation without the title holder of record being involved in such an agreement.
I guess the only comment I would make is that in addition to what I've already said, is that it's not just me saying this, it's the California Supreme Court and nearly every state Supreme Court that has looked at this issue since Jones has read that paragraph in the way I described it. So I guess certainly reasonable minds can differ, but I think the great weight of legal authority is in that interpretation. Now, maybe the U.S. Supreme Court will come back to that. I think someone in the earlier panels mentioned that it has been 30-some-odd years since the U.S. Supreme Court has delved into the intra-church property disputes, and maybe with a new court with new members, who knows what they'll do. But I think that the state of the law very clearly is, I think, in the way I was articulating it.
Well, I think
I respectfully disagree with that assessment of the state of the law, but reasonable minds can differ.
Okay, and on that note, with perhaps a new phrase for the ages of unilateral ecclesiastical appropriation, which I like the ring of that, please join me in thanking our wonderful panel.
Let me quickly put my conference director hat on and say thanks to these two lawyers. When we organized this conference, of course, we didn't know how the Virginia and California cases were going to do. We wound up picking the winning lawyer in each of the states, at least as it currently stands. And I think we saw why. Thanks so much, Jeremy and Steffen.